items, and that's it. Obviously, we're being recorded, and I understand we're being recorded by the Sun. Anybody else recording? That's fine. Okay. We got two things up. At least that's what the agenda offered. The first was continued discussion of the zoning article that pertained to chickens. I've talked to people on both sides of this, actually some pretty good discussions. And at this point, I think everybody's agreed that to get this done right, we will take it to April, and we're going to work on it from there. And I've had good conversations with people on both sides of this. I think we actually may be on a path to get this resolved to everybody's satisfaction. At least I hope so. So we're not going to be considering that tonight beyond the statement that I just made. The item was pulled from the warrant, so it's not going to come up tonight. The second item was a very technical zoning article having to do with exactly how you calculate lot area on certain kinds of lots with narrow strips connecting pieces. And I got to admit, it's been a long time since I had geometry, and that's what this is all about. But at the request of the town, Paul, our town attorney, I said I'd bring this back up to the board. And Paul, if you want to tell us what this is all about.
Certainly, Mr. Chairman. For the record, Paul Haverty, Blackwood Trustee, Haverty Town Council. I apologize that I was not able to attend the last meeting of the planning board when this was discussed. I think I probably would have helped explain the circumstances a little bit. If the board members recall, sometime last fall or early winter, there was an applicant that came before the board with an A&R plan. That A&R plan sought to split off an existing house and the rest of the property and create what would ostensibly be a buildable lot on as a vacant parcel, and then leave the existing house as a non-conforming lot. But what that did was that left the newly created ostensibly conforming lot as subject to compliance for zoning for the other lot. So in an attempt to turn that lot into a buildable lot, there was an A&R plan file that created a very long, narrow strip. It was 2 feet wide, approximately 100 feet long, which initially a building permit was then granted for the other lot, believing that the lot area deficiency had been cured. But then subsequently, the prior building inspector rescinded that building permit after making a determination that the definition of lot area contained in the zoning bylaw would have excluded the smaller portion of that newly created lot. And if you look at the definition, it does, I'll read it off so everyone can understand what we're talking about. Although again, because the geometry comes into play, I'm not sure if everyone will understand what we're talking about. The horizontal area of the lot, exclusive of any area in a street or recorded way open to public use. At least 80% of the lot required for zoning compliance shall be contiguous land. Other than that, under any water body, bog, swamp, wet meadow, marsh, or other wetland, as defined in MGL Chapter 131, Section 40, as amended. And then it says, when the distance between any 2 points on lot lines is less than 50 feet, measured in a straight line, the smaller portion of the lot which is bounded by such straight line shall not be considered in computing the minimum lot area unless the distance along such lot lines between two such points is less than 150 feet. And then the bylaw actually contains 2 diagrams. And in the first diagram, it shows 2 lots that intersect, has a hatched area, and then specifically shows the length of those 2 lines as less than 150 feet, and instructs you to add those 2 lines to get to a total that's over 150 feet. So in that circumstance, it was very clear that that area would be excluded from the calculation of lot area. However, the second diagram shows a strip, not quite as narrow as the one we were looking at in a particular instance, but it was a strip and then a bigger portion on the other end. Doesn't contain any information as to what the length of that strip was. It doesn't give any sense as to whether you add those 2 lines or not. So when there was an appeal taken to the Board of Appeals, that question was asked. The zoning enforcement officer actually referred it to the State Board of Building Registration and Standards to see how they would interpret it, which is obviously not a binding issue, but he wanted to get an understanding. as to if this was to become a contentious issue, how would it be interpreted? And they interpreted it as not counting those two lines, not adding them together. So in that particular instance, it left it that the lot that was newly created became conforming, and the other lot was thus buildable. But it then presented a significant concern for me, and I think one that should be a concern for this board as well, which is it would allow people to come in and really do some crazy things with lot lines to try to do an end around the definition of lot area, and you wind up with very odd shaped lots. So while we were, while the zoning enforcement officer, the building inspector was granting the building permit for this, we also decided that it was necessary to clarify the bylaw. So the proposed language simply states that for the purposes of computing the 150-foot minimum distance, the length of each lot line shall be added together, irrespective of whether the two lines intersect. So all it's trying to do is bring it back to what the interpretation was previously. So that second diagram, this is basically saying you would add those two lines together, even though it doesn't tell you to in the diagram. We could have just fixed the diagram, but that was way beyond my drafting skills. My understanding was that there were some concerns raised at your last meeting as to how this would impact existing lots. Again, Chapter 48, Section 6 protects grandfathered lots. Any lot that's in existence before today, before this matter comes up before the town meeting and is voted upon, would not be subject to the change in the bylaw.
Okay, yeah, because I think we were mistaken to some degree in considering that the time of exclusion worked itself back to the point.
So if you were trying to get the exemption based upon the issuance of a special permit, or based upon the issuance of a building permit, and that building permit was issued after the first notice of the public hearing, then you wouldn't be able to establish grandfathering rights under that scenario. But generally speaking, this, the way this would work is you would have an existing lot.
Okay.
Right? It wouldn't have anything to do with the building permit, wouldn't have anything to do with the special permit. You've got a lot that existed yesterday, and it had this particular configuration and would be technically, under the current interpretation, would comply with the lot area requirement. Then it would be grandfathered tomorrow after the town meeting takes its
Okay, so
vote.
that happened tomorrow. Very good. Anybody on the board?
So there's two lots in the town that's under question right now?
There's no lots that are under question right now. There was a lot that took an appeal, and that's how this question, was brought to my attention. And in the course of that appeal, building inspector and I took a look at this. Again, he referred it to the state. They came back with a suggestion, and the building inspector and I said, we sort of agree that a technical reading of the bylaw, the language is insufficient to accomplish what we think it's trying to accomplish. So that building permit was issued, and that lot, construction will be able to move forward. I'm not aware of any other specific lot.
I thought
that's
the one
in
on
question.
Weston Street was in question as well.
Well, I don't know the particulars of that, but other than to say, if the lot exists today, then that lot would be grandfathered if the bylaw is changed.
And I believe we did do an A&R on that.
I just don't want to see somebody that we voted a project forward for them, now have it taken away from them.
I would be a little surprised if it would have been applicable to another lot anyhow, because again, the interpretation previously was this wouldn't comply. So
We had voted down another one that had to go around a bunch of different ways. The only other question I have for you too is, one of our board members asked if this was going in front of town meeting. It's a very complicated thing, if we could have some better diagrams and descriptions for people. And this is the problem of bringing something to us the night before, with the last meeting before planning, before town meeting.
And that is perfectly understood, but again, this was a situation where we were leaving the current interpretation and creating an opening for things to be done that we didn't think would be appropriate. So there was a very specific time crunch with regards to this, and again, way beyond my skill set to try to do the diagrams. So I instead chose to try to address it through language in the bylaw.
So if we're comfortable with the language, are you comfortable presenting it as you did this evening?
So what I would ask is for Evan to make the presentation to the town meeting, because I think it's appropriate for for me as town council to sit up at the dais and actually
Give them the
advocate
material,
for.
give them the material you have, Evan, are you comfortable?
Absolutely.
Yeah, the amendment.
And I can certainly discuss any questions that come up.
I got a question.
as a
Yeah,
result.
sure. You're on. Ed?
Okay, you got the tape. All right. You may not have any questions, but there are two property owners that have serious questions as to whether or not they're going to be able to, one, continue building, and two, build. Lots on Western Street and the others on Hildred. No matter what you say tonight, as this thing goes forward, they still have serious questions, okay? They brought them to me. Okay? As a town meeting rep and as a planning board member, they brought them to me.
So the lot on Hildreth, I believe, is the one that was actually the.
But there's another one that we did an A&R on, and that person, I believe, has hopes of building a house there. And so at some point, he's gonna get a building permit, or at least try to get a building permit. So when we do an A&R, as you well know and you've instructed us, we're not looking as to whether it meets zoning regulations or not. All we're concerned about is meeting frontage, which is what we do based on previous lawsuits, I believe, we've had over the years. We make sure it's accessible, it's on public way, yeah, so there are people in town that have questions, and number one, I don't want them hurt with this. Number two, I hear the jazz you're giving us, and I apologize for that term, but I'm annoyed by it because I brought it up a couple of planning board meetings ago, that you don't have the drawing skills to do the drawing. That's fine. Go out and get an engineer or a surveyor to give us a drawing that we can put in the bylaw. That's what I'm looking for. That's why I voted no. That's why I'm going to vote no on anything tonight on this. Third, this diagram that's in here already should have told the building inspector, building commissioner, that it wasn't a legal lot. Because over the years, we've had many bow tie lots that have had problems getting permits. You can think of one on Stedman Street. And this one clearly shows a bow tie lot. And so therefore, the instructions were in the bylaw under the definition of lot area for it. So what I find fault with this whole thing is, you've given us verbiage. It took me a couple of days of reading it and reading it and reading it to try and understand your verbiage. It may be clear to you as a senior attorney, but it's not clear to me as just a common person, even I have engineer training, but it's not common, it's not, I know it's clear language, but understanding it doesn't, the understanding of it is difficult. So I guess I've gotten it off my chest, you heard about it, and my vote is no for anything.
I'm sorry, and your vote is no to allow town meeting to discuss this, or?
No, we have no,
We have
we have no, the only thing that's,
I tell you, fine. We voted to withdraw, I think we voted to
We
withdraw.
voted wrong to
Yeah.
withdraw because it's not our article. Therefore, if the applicant being Paul is comfortable
Yeah.
moving forward, why don't? we
this
go ahead and-
is coming up tonight.
Yeah.
The question that we have before us is, do we want to endorse it
Right.
as the planning board, which is a perfectly reasonable request. It's a request that's made to us fairly often on a lot of zoning things, and I think we should at least entertain the request. So,
And Chairman, if I could just
Yeah.
address Ed's points. First point, Ed, is any lot that exists today will not be subject to any increase in lot area requirements that would be adopted by town meeting tonight. That's straight out of General Laws, Chapter 48, Section 6. So your first concern, although, I mean, I think it's commendable that you are concerned about taking away rights from the existing lot owners, the state requirements, don't allow that to happen. So I don't think that there is a needed concern on that issue. The second issue, again, this was something that came up very recently. The need to address it, while there was a town meeting that was actually already scheduled and was going to be happening, led to it being addressed the way that it was addressed, which included not going in and doing a new diagram because I don't have engineering skills. That's way outside of what I'm capable of doing. So that's why it was addressed with verbiage. That does not mean that come spring town meeting, if the planning board wants to work on this in the interim, they could create new diagrams that would actually clarify things better. I think that would be wonderful. All we were trying to do was to close a loophole in the law that opened up to make sure that you didn't wind up with numerous applicants coming in trying to push forward A&R or subdivision plans that showed lots that didn't comply with the intent of the bylaws previously.
Okay, anybody else on the board? Otherwise, I will entertain a motion one way or the other. Yep.
Just as an opinion, it took me a lot of concentration to figure out what this additional statement is saying. I finally figured it out. This entire definition is confusing, but I can see where the added sentence does help with the current situation we're having of abnormally formed lots. So I'll vote to endorse it, but I would certainly like to have it put on our work agenda to revise this entire definition for spring town meeting.
Okay.
So motion to positively recommend Article 1.
I have a motion to recommend Article 1.
Second.
I have a second. Any further discussion?
We are under the impression though that the people like we just talked about wouldn't be affected, like Ed said.
They have existing lots.
Any existing lot is protected under Chapter 48, Section 6.
The only way I'll vote for this is if we do something to clarify it or put something together for in the springtime.
Yeah, let's work on this.
Which is what we had said
Yeah.
at our last meeting was, let's put this off the spring because this is way too confusing for
I
people
don't
to
know
come
what
in
the
and
big
look
rush
at.
is to get this done tonight.
I really don't know either because of how
It's
how
all of
many
a
lots
sudden
do you
this
know?
popped up, there's one, possibly two incidents in
Years.
how many years? And all of a sudden, it's gotta be put to bed tonight.
The reason
We've had
is.
at least two in the last year.
The reason
Yeah.
is, knowing that this is likely to change, you're gonna get a rush
Anybody.
of people with really screwy looking lots,
Yeah.
trying to get in before the matter gets
Yeah.
passed. I think there is a pretty good reason for taking care of this now, and then we can clean up the artwork. Clean up the artwork in April.
I don't think I'm in favor of it.
Okay, well, now, we've got a motion. Do we have a second?
I
Second?
seconded.
Any other
Can I vote on this?
That's a good question.
No.
You came in a little late.
Yeah, no,
He's alternate too.
Yeah. All right. All in favor?
Aye.
Aye. 3. Opposed? 4. It does not pass.
Okay.
So are you reporting that we voted not to endorse it on a...
I'm reporting that we did not endorse. That's, I think, all what that vote was. And if you want to give it a thumbs down, we can do this again. But what I intend to do, based on what we've done here, is to get up and say no recommendation on the part of the planning board.
We gave it a thumbs down at the last meeting of the meeting.
Last meeting we gave it a thumbs down. We did the same basic vote last time.
No, you didn't have that many people there, was it?
No, we only had 4 people last time.
All right,
Okay.
on to town meeting.
Yep.
Motion to adjourn.
Second. All in favor?
Aye.